Major breaking news, ladies and gentlemen. The case against James Comey has been dismissed on the grounds that the prosecuting attorney was unlawfully appointed. Of course, many people on the left had been arguing that the prosecution against Comey was going to be weak and would likely be dismissed. It is being dismissed without prejudice, meaning they can bring this case back up. But as of now, it is defeated. Now, I think it's apparent to most people when you're reading the news, James Comey had to have known about what was going on, making his statements apparently lies. The question is, can you get through this system? As the story went, the initial prosecutor, the attorney in this area, refused to bring the charges, so this person was fired, a new individual was hired, and now here we are with the breaking news. Let me get right to it for you guys. From CBS, judge orders James Comey case dismissed after finding top prosecutor was unlawfully appointed. They say a federal judge on Monday ordered the criminal charges against former FBI Director James Comey to be dismissed on the grounds that Lindsay Halligan, the interim U.S. attorney who secured the indictment, was unlawfully appointed to the role. The ruling from U.S. District Judge Cameron Curry is a significant victory for Comey, who has argued his prosecution is retaliatory and motivated by President Trump's efforts to punish his political foes. The Justice Department is likely to appeal Curry's ruling and asked for it to be halted. But Comey's lawyers are seeking to have the indictment tossed out on numerous other legal grounds, including that his prosecution is vindictive and selective. A decision on the argument remains pending. So we have the actual document here. Now, I want to stress what we have seen with these rulings against Trump. This is the war, ladies and gentlemen. This is the lawfare. Be it Donald Trump's deployment of National Guard, be it his ruling on immigration, judges have consistently ruled against Trump, then been overturned. Let me show you what the judge actually said, and then we'll discuss whether or not this can actually fly. With the document here, in the United States District Court for the Eastern District of Virginia, Alexandria Division, U.S. v. James Comey. Opinion and order granting motion to dismiss the indictment. On September 25th, 2025, Lindsay Halligan, a former White House aide with no prior prosecutorial experience, appeared before a federal grand jury in the Eastern District of Virginia. Having been appointed interim U.S. attorney by the Attorney General just days before, Ms. Halligan secured a 2-count indictment charging former FBI Director James Comey with making false statements to Congress and obstructing a congressional proceeding. Mr. Comey now moves to dismiss the indictment on the grounds that Ms. Halligan, the sole prosecutor who presented the case to the grand jury, was unlawfully appointed in violation of 28 U.S.C. 546 and the Constitution's appointment clause. As explained below, I agree with Mr. Comey that the Attorney General's attempt to install Ms. Halligan as interim U.S. attorney for the Eastern District of Virginia was invalid. And because Ms. Halligan had no lawful authority to present the indictment, I will grant Mr. Comey's motion and dismiss the indictment without prejudice. They say the Appointments Clause prescribes the exclusive means of appointing officers of the United States. The text of the clause contemplates 2 types of officers: principals and inferior officers. Principal officers must be appointed by the president with the advice and consent of the Senate. The same process is also the default manner of appointment for inferior officers. But the framers recognize that requiring all officers of the federal government to run the gauntlet of presidential nomination and Senate confirmation would prove administratively unworkable. So on one of the last days of the Constitutional Convention, they also authorized an additional and streamlined method of appointment for inferior officers. In the final provision of the Appointments Clause, that provision sometimes referred to as the Accepting Clause. But let's pause real quick to give a shout out to today's sponsor, PDS Debt. Check out pdsdebt.com/Timcast today. Debt from credit cards isn't an accident. It's a system built to keep Americans down. The banks profit, the creditors win, and families lose. Every call, every fee, and every high-interest trap is another reminder the game is rigged. But there's another side of the story. PDS Debt has already helped hundreds of thousands fight back, cutting debt, ending the calls, and putting money back where it belongs, in Americans' pockets, not the banks. Whether you're struggling with credit cards, personal loans, or medical bills, PDS Debt has custom options to help you get out of debt. They go beyond the numbers to understand your unique financial situation and craft a personalized plan designed just for you. There's no minimum credit score required. They're here to help you save more, pay off your debt faster, and start putting money back where it belongs, in your pocket. PDS debt is A+ rated by the Better Business Bureau, boasts thousands of 5-star reviews on Google, and holds a 5-star rating on Trustpilot. Why? Because PDS has helped hundreds of thousands of people get out of debt. It's your money. It's your future. Don't let the system decide for you. You're 30 seconds away from being debt-free. Get your free assessment and find the best option for you right now at pdsdebt.com/Timcast. That's pdsdebt.com/Timcast. Edmunds 520 at 660 permits Congress to by law vest the appointment of inferior officers in the president alone in the court of laws or in the heads of departments. For U.S. attorneys, Congress has preserved the constitutional default rule of presidential appointment and Senate confirmation. With the advice and consent of the Senate, a U.S. attorney for each judicial district, blah, 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 we get it. Congress has also established a mechanism set forth in 28 U.S.C. 546 for appointing interim U.S. attorneys when a vacancy arises. Section 546 essentially divides the responsibility for making interim appointments between the Attorney General and the district courts. They go on to say, background. On January 20th, Jessica Aber, who had been nominated by Biden and confirmed by the Senate, resigned from her position as U.S. Attorney for the Eastern District of Virginia. The following day, an Attorney General appointed Eric Siebert as interim U.S. Attorney. Mr. Siebert's 120-day interim appointment was set to expire on May 21st of 25. So on May 9th, the judges of the district exercised their authority under Section 546D to appoint Siebert to continue his role. On September 19th, Siebert informed colleagues of his resignation. According to news reports, Mr. Siebert had recently expressed concerns to senior Department of Justice officials about the viability of pursuing charges against Comey and the New York Attorney General, Letitia James. Mr. Siebert's resignation came hours after President Trump told reporters at the White House he wanted Mr. Siebert out. The next day, President Trump posted and later deleted the following message. Pam, I have reviewed over 30 statements and posts saying that essentially same old story as last time, all talk, no action. Nothing is being done. What about Comey and Adam Shifty Schiff, Letitia? They're all guilty as hell, but nothing is going to be done. Then we almost put in a Democrat-supported U.S. attorney in Virginia with a really bad Republican past. A woke rhino who was never going to do his job. That's why 2 of the worst Democrat senators pushed him so hard. He even lied to the media and said he quit and that we had no case. No, I fired him. And there's a great case, and many lawyers and legal pundits say so. Lindsey Halligan is a really good lawyer and likes you a lot. We can't delay any longer. It's killing our reputation and credibility. They impeached me twice, indicted me 5 times over nothing. Justice must be served. Less than 48 hours after Trump's post, the Attorney General issued an order authorizing Lindsey Halligan to be the interim U.S. attorney for the Eastern District. So let's just cut to the chase. It seems, based on Trump's posts, they are now claiming this U.S. attorney is invalid, finding it necessary to determine the extent of Ms. Halligan's involvement in the grand jury proceedings. I ordered the government on October 28th to submit for in-camera review all documents relating to our participation before the grand jury, along with complete grand jury transcripts. Upon reviewing the transcript provided by the government, I determined it did not include any remarks made by Ms. Halligan before and after the testimony of sole witnesses. Accordingly, November 4th, I directed the government to submit a complete transcript and or recordings of all statements made by Ms. Halligan to the grand jury. In a notice of compliance, et cetera, we understand. Let's jump down to the bottom. Resolving Mr. Comey's motion requires me to first decide whether Ms. Halligan was validly appointed as interim U.S. attorney under Section 546 in the Appointments Clause. If the answer to that question is yes, I need not go any further, and Mr. Comey's motion must be denied. But if the answer is no, and Ms. Halligan had no authority to present Mr. Comey's indictment to the grand jury, then the question becomes what remedy is appropriate. Should the indictment be dismissed? And if so, should the dismissal be with or without prejudice? I address these issues in turn, beginning with whether Ms. Halligan's appointment was valid. They go on to then, she basically goes on to say it was not valid. The text and subsection of D in particular make it clear the appointment power shifts to district court after the 120-day period and does not revert to the attorney general. If a court-appointed U.S. attorney leaves office before a Senate-confirmed U.S. attorney is installed, the first word of subsection D, if, introduces a conditional clause that establishes the condition triggered the district court's authority. Long story short, the argument is, they say this reading is reinforced by the negative implication canon. Let me just get to the gist of it. I want to make sure I have the judge's words. They're basically saying this, we've got a guy who resigned. He may have been fired. They then appointed somebody, but the authority didn't fall with the attorney general to do this. They say, finally, for those who find it relevant, the legislative history confirms Congress sought to eliminate the executive branch's ability to circumvent the Senate's advice and consent role. Basically, she's saying Congress must confirm the attorney. I'm going to go ahead and say this. We'll scroll to the bottom. I believe this is lawfare. I believe the judge is simply saying this because they don't want charges to be brought against Comey. Having found that Ms. Halligan's appointment violated 28 U.S.C. 546 in the Appointments Clause, and that dismissal of Mr. Comey's indictment is warranted, the remaining issue is whether dismissal should be without prejudice. And ultimately, she says, without prejudice. Charges may be brought if they get a better, more constitutionally appointed individual. A major defeat for Trump, but it's not over, though many people will complain judges are obstructing. Trump can't get the job done. My friends, I fear that we're heading down a dark path. We'll have more for you tonight on this issue, but here's the breaking news as of now. They say, so it is ordered the appointment of Ms. Halligan violated the Constitution. All actions flowing from Ms. Halligan's defective appointment, including securing and signing Mr. Comey's indictment, were unlawful. The Attorney General's attempts to ratify Ms. Halligan's actions were ineffective. Stay tuned. We'll be back tonight. Thanks for hanging out, and we'll see you all at 8 p.m. for Timcast IRL.